Festus Keyamo, disgraced in court, ordered to pay 10 million naira to Atiku, INEC. A federal high court Abuja on Monday awarded a 10 million naira fine against Mr. Festus Keyamo, former Minister of State for Labour and Employment, for filing a frivolous suit against Atiku Abubakar, the People's Democratic Party (PDP's) presidential candidate in the February 25th election. Justice James Omotosho, in a ruling, awarded a 5 million naira fine each in favor of Abubakar and the Independent National Electoral Commission, Independent Corrupt Practices and Other Related Offences Commission (ICPC), making a 10 million naira fine against Keyamo. Justice Omotosho, who described the suits as frivolous, vexatious, and abuse of the court process, directed that the fine should be paid at 10% per annum until the cost is finally liquidated. The order followed an oral application by counsel for Atiku, Ben Ibanoi, and that of the ICPC, Oluwakemi Odogun, asking for cost after the matter was dismissed. Keyamo, who was also the spokesperson of the dissolved Tinubu-Shettima Presidential Campaign Council, has filed the suit marketed FHC/ABJ/CS/84/2023 on January 20. In the application, he had sought an order compelling the Economic and Financial Crimes Commission (EFCC) and ICPC and CUCB Code of Conduct Bureau to probe and prosecute Atiku. Keyamo based his action on the ground of claims by one of Abubakar's aides, Michael Achimugu, that between 1999 and 2007, when he was vice president, Achimugu conspired with ex-president Obasanjo to rip off the country using what he termed special purpose vehicles. The ex-minister filed the suit after the 72-hour ultimatum he gave the three investigating agencies elapsed. He alleged that Abubakar was in violation of Section 8(2) of the Money Laundering Prevention and Prohibition Act 2022 and Section 98(1) of the Penal Code, hence unqualified to contest in February 25th poll. But Atiku, through his lawyer, filed a notice of preliminary objection, seeking for an order dismissing the suit for being incompetent, lack of focus standi, want of jurisdiction, and for non-disclosure of reasonable cause against him. The EFCC and ICPC and the CCB, in their separate preliminary objections, also challenged the competency of the suit and jurisdiction of the courts. Delivering the ruling, Justice Omotosho held that he had two issues for determination, and that was whether the suit was frivolous and whether the relief sought by Keyamo could be granted. The judge, who said the jurisdiction of the courts would be determined, also said that the locus standi of the applicant would also be looked into. Locus standi is the capacity of a party to institute an action. It interrogates what is the business of the plaintiff with the defendants. The need for proper locus standi is to prevent busybody from instituting a suit and restraining them from wasting the time of the court, he said. He said though the court did not say that the ex-minister did not have a right to write statutory agencies to investigate Abubakar, but that he had not shown why he was affected by Abubakar's action. A citizen of a country has a right to report crime, and that cannot be an infraction of fundamental rights of any person. But the complaint is to complain to the statutory agencies and not to drag the first defendants with the agencies to court seeking an order to compel the agencies to investigate the suspects, he said. Justice Omotosho held that investigating authorities had the discretionary powers to investigate any case and to know if such case would warrant any prosecution or not, citing previous cases to back his decision. The law is that the court cannot compel investigating agencies to perform their discretionary powers, he said. The judge, who read Keyamo's letter, wherein he gave the investigating agencies 72-hour ultimatum to investigate Abubakar, said the Court of Appeal, in one of its decisions, cautioned public officers against abuse of powers. He said that it was unheard of that a citizen would give statutory agencies 72 hours to investigate and prosecute an alleged offense. And immediately after the 72 hours, an action was filed. The question is 72 hours sufficient for the investigation and conclusion of action of this nature? The answer is no, he said. Omotosho, who said that Keyamo did not even give a reasonable time for the statutory bodies to act before filing the suit, said, "This means that the action was filed in bad faith." Also, Abubakar's lawyer, Mr. Ibanoi, prayed the court for a 200 million naira fine against Keyamo, considering that his client was former vice president and presidential candidate in the last election. Okay. The judge, however, awarded a 5 million naira fine in favor of Abubakar and ICPC. Well, make sure to leave your opinions in the comments down below, like and subscribe, and don't forget to share with your family and friends so they know what is going on and can give their own views on this. And make